Hello, come on back.
Whitney, I just noticed your name is backwards on the screen. It must be the camera that like inverts it. I'm like, I'm trying to read it. And I'm like, what? Like, what is going on?
Where's it say that?
Backwards
Keeping
I
on
don't
your
see
toes.
it.
on the screen or a name
There's
tag.
an option somewhere you can reverse it.
I just,
Oh,
I
you-
was trying to read it though, but
Upside down.
I'm like, why does it look that way?
Hi, folks, welcome back. We are now back in session and we apologize for the delay. Rob, if you could please call the first case.
Yes, this is infield land use case Z 25 0, I'm sorry, it was 04-01, but I did change it there to 0501. She had applied, but she could not make the last meeting, so we bumped it to this meeting. Freedom Rules Trust, Barbara Rule trustee has applied for variance relief from Article 4, Section 401.1, Paragraph K of Enfield zoning ordinance to allow a lot to be less than 1 acre in size. Ms. Rule is seeking to merge 3 lots into one at Johnston Drive. They are found on the town tax map 14 and are lots 14-9, 14-8, and 14-8A respectively. These lots are all located within the R1 residential zoning district. And Barbara, if you wouldn't mind, come up and sit in one of these
Sure,
fancy chairs here.
sure.
Make yourself at home.
Ms. Rule, welcome.
Thank
for
you. Thank
coming.
you so much. Thank you for having me.
Is it okay if we call you Ms. Rule? Is that?
That's fine.
Okay.
Sure. Yeah.
All right, so here's just a couple of things I want to remind you of, is that we're reviewing a variance for a particular parcel. Our judgments will be based on the town zoning ordinances and a set of criteria for a variance. Our judgment is not a reflection on you at all. We're looking at
Understood.
the property. Any variance granted to the parcel is granted to the parcel, not to the owner. So if you were to sell it in the future, what we do here will follow the land.
Sure.
So the responsibility, however, falls on you, the applicant, to successfully argue the variance should be granted for this parcel.
Sure.
Does that all make sense?
Sure.
Okay,
Uh-huh.
great. Please take a couple of minutes, describe the situation, describe your request, and present your arguments. We'll allow you to do that uninterrupted, and then we're gonna ask you some questions.
Sure.
Okay? Thank
Sure.
you.
So, I purchased, certain lots of land about, in 2015, I think it was, or longer. And these 3 lots were, across the street from a trailer park, and I think the previous owner just turned this into like trailer park lots that were each 0.2 acres.
I'm sorry, I mentioned earlier I am new. I need to mention that seated for this particular case
Uh-huh.
will be Tim Linehan, Susan Brown, Bill Finger, myself, and Tiffany Adams.
Sure,
Celia's an alternate. She will participate, but she won't be voting in this
sure,
particular case.
sure.
Please continue.
So, anyway, when I purchased the 3 lots, one of them is literally, like a brook area that has woods on both sides, which, I don't even know why anyone would separate that as a lot. I don't know the history behind why they were such small lots. But I purchased the 3 lots. I removed this dwelling, which were trailers. And those are gone now, and I want to merge all 3 lots since they are contiguous, for reasons such as not having 3 tax bills.
Yeah.
Also having a less non-conforming lot than the 3 separate would be for any future improvements that may come along.
Okay, we got Vanna here at the screen. Go ahead.
It's me.
Oh,
So-
thank you.
Just to orient you guys, here's Route 4 coming in. This is the Lebanon line.
Yeah,
She was referring to manufactured housing. There's 3 of those in this vicinity here. Johnston Drive tucks in right on in Lebanon, actually, and then kind of dives into Enfield here. Some of you will remember these lots were Enfield is dealing with. I think we now own several of them. The 3 lots that Barbara owns, Ms. Rule, are these 3 here. You can see them tucked in this corner. So it's 1, 2, 3.
gotcha,
Mhm.
gotcha. Thank you.
Question?
Why don't we allow Ms. Rule to continue?
I thought
And
you
then,
had finished.
no, she is not. I interrupted.
Oh,
Vanna did.
that's fine. So, on those lots currently
Mhm.
are no improvements. There is a dilapidated garage which will be torn down. which I would like to replace. But, there, I don't see why I have to have three separate lots that are vacant, why they can't just be merged voluntarily. So
Gotcha.
for the simplicity of it.
Okay.
And also to be less non-conforming than what your rules are now.
Okay, got it. Thank you.
Yeah.
So I'll now ask the board, if they have any questions for you. We'll go one at a time. And, they're gonna ask the public if they have questions, and then we're
Perfect.
gonna talk about it stuff. Susan, why don't you start us off?
Well, I've driven by there and I've been to Barb's house.
Oh, yeah.
That building that I can see from Route 4, that's the garage. That's not a house.
It's a garage.
It's a garage.
It's a, yeah, it's a dilapidated garage. I mean, it's basically a shed, storage space for me.
Mhm.
Yes, that's what that is.
So were you intending to build there?
I would like to replace the garage with a better garage,
Uh-huh.
since my home is across the way and the town line goes right through my front yard, so my home is in Lebanon.
I thought that's what it was.
Okay.
That she lives there.
Right, right,
Now I understand. Yeah,
Right.
there's a house there.
right. I live in the house.
Yeah.
And that yellow garage and the two empty lots with the yellow garage, that's the one.
Yeah.
I miss the chickens, they're gone.
They had chickens at that.
Right,
that Front.
there were some
Trail,
chickens for a
yeah.
while, yeah. They're gone. As is the tenant and his trailer.
Okay, Susan, do you have other questions?
No, I always have to look in 3 dimensions. So when a case comes up, I go and look.
All right, no questions?
No, I'm
Okay.
finished with questions.
Yeah,
I
what do you-
got
No,
no answer.
that was my question, was that I thought that was the case, that you lived over the town line,
Right.
and these are in
Yeah.
our town.
And where I live is, so I park my car in Enfield and I walk to my home, my living room in Lebanon. So,
I love access. I'll tell Lebanon, they'll want me.
Good?
I'm good.
they know I'm there.
Yes. Are these properties on municipal sewer?
No. No town water or sewer. There's no services there.
Because the trailer park has a septic system,
Yes,
they have.
Nice.
and this
Yeah,
one,
Just working on it.
this one had like a tank, and when the trailer was moved away, the tank has been, sort of buried. So there's no septic or any sort of infrastructure or improvements whatsoever, other than what you see in this photograph here.
Just as a curiosity, where'd they get their water?
Well, there was a well that fed both two trailers, and both of those trailers were removed, and so the well has no like pump house or anything. It probably could be reused again. I would like to use it so I can, because I plan on putting some apple, like an orchard there, and maybe I can get some water to run to it.
Bill,
So,
are you good?
Yeah.
Okay. Ms. Rule, in the application, under the third criteria, which if you remember is substantial justice is done. You state the combination of 3 lots would allow for future plans to improve the lot and beautification.
right.
Can you share with us what those specific future plans are?
Well, the plans have always been a little fuzzy, but right now, all I want really is to replace the garage
Okay,
and use the space for an apple orchard.
how long ago was the garage taken out?
Taken out, the garage is still there.
Okay, so the garage, you would just.
I would just replace that, what's there, tear that down and put another garage.
Got it, got it, got it. Okay, thank you. In the application, the 5th criteria, which is literal enforcement. You ask, would the ordinance allow me to improve the land without merging? What do you mean by improve the land in this case?
Again, from what I understand, that you cannot do any improvements upon a lot less than 1 acre in Enfield.
In the R1, the ordinance states, which is 401.1, the R1 district, letter K, minimum lot size shall be 1 acre, except for dwellings in which minimum lot size shall be 1 acre per dwelling, blah, blah, blah. So yes, basically it's 1 acre.
That's what I'm saying. So what I have is a 0.2 acre.
Yeah.
Next to a 0.2 acre. And then the backup is like a 0.5 acre. So combined, and I did put a survey here so you could see the combined.
Yep.
Total would be 0.78, 0.76 of an acre if they were all together. So it just makes more sense to me, like I'm not gonna build something on a 0.2, you won't let me, I wouldn't anyway. I
Yeah.
don't want to.
Yeah.
I wanted to get rid of that because it's, it's now this is my home.
Yeah.
Attached to my home. So what I just wanna do is have one lot, one tax bill, one improved garage, and perhaps maybe more improvements beyond. I have no plans for anything further than that right now.
Okay.
But it'd be nice to have a future where maybe there is another home built there. I don't know. I don't intend to right now.
Okay.
Maybe my son moves here.
I just want to clarify that these are all legal lots of record in Enfield.
Yeah.
And she does have rights on each one of the three. Setbacks is gonna be one of her biggest challenges with small tiny lots
Yep.
like what she's got. Septic system is gonna need to be squeezed in there somehow. And so those are big issues, obviously. So she's right that it would be easier if they were all put together.
Mhm.
But I just want to correct you that
Thank you.
you do have rights on each of those lots. And obviously mobile homes on them.
Yeah.
Those were legal, that was legal
Right.
use. It's obvious the setback is gonna be the biggest challenge for the really, really tiny lots, which we see a ton of in Enfield,
Sure.
especially on the
You could
lakes.
put a postage stamp in the middle. That's
Exactly.
it.
A dollhouse or a doghouse, I always joke.
Right, exactly.
She could put a garage in this existing footprint though, right? If she wanted to build like.
Yeah, in terms of this, dealing with the setbacks, she could recycle the footprint for sure.
Sure, yeah. And maybe,
If-
maybe I do want a little bigger, but
Does she have to have, there's concrete pads there that you'll have to take out.
or use them for a greenhouse or some other, or shed. I don't know. I haven't decided, but I feel like why tear up a perfectly good pad? If there, could be a
Or
future.
you're saying,
Yeah.
or maybe. think-
Well, there's plenty of room beyond that. No, there's plenty. I'm gonna plant 5 apple trees tomorrow, so that's
Oh,
a start.
nice.
Nice. Nice.
They must be beautiful right now.
Everything's so green and lovely. It really is.
Tiffany, questions?
I do not have any.
Okay, I have another, and then we'll see if other people have one. So my understanding is you went to the planning board a number of years ago and talked about this.
Yeah. I mean, I just purchased the property and wanted to merge it then and was talking about maybe doing kind of something similar. I mean, maybe single family home, but I don't have the funds to build a spec house, and I don't really want to see my neighbors over there, so.
Silly. Do you have any questions?
I just wanna know whether you were talking about, stream.
Yeah.
Where is that?
Well, behind where number 8 is,
Yeah,
in the center of 8 runs a brook, right down the middle of
is
it.
that shade? Okay.
Yeah, right down the middle of it. Actually, I know my land goes to the other side of the brook, but it's very deep ravine.
Uh-huh.
It's a very deep ravine, so in itself, because there's a brook there, the setbacks are 50 feet from that brook. It was 30, now it's 50. So it basically just becomes a nice buffer between us and the neighbors and a wooded land where, the animals come through. All kinds, bears, deer,
Mhm.
moose,
Yeah, good.
trout.
I just have one question that came up. Because it relates to the septic, because I can imagine somebody puts a garage in, if that well is defunct now, if you wanted running water to,
Yeah,
I don't know, wash a car, wash a boat,
uh-huh.
water apple trees.
Yeah, I do want water and I'll have that assessed with
And
the
so-
well people.
Do you think that if the lots were combined, it would allow for you to have an easier septic design
Oh,
than?
definitely.
Than now? Okay.
I think so. I mean, there's only so many places a septic could go. In fact, I wonder if even on here, there might be a suggestion. No, but it's something. Definitely, if they were merged together, all those things are possible. Without the merger, none of those things are possible.
Yeah, just a lot of those mobile home type places, we know what the septic was.
They had a tank,
Let's go.
they had a tank, you know, underneath the trailer,
Yeah.
that went with the trailer.
Yeah,
So
all right.
it's not like field, but there probably is a designer somewhere that could figure that out if I needed one.
Okay,
Certainly more easier if it was combined.
great.
Yeah.
I'll tell you what, if there doesn't look like there's any more questions at this time, let's go and open the public session. Is there an abutter here that would like to speak?
No, butter.
No butters, okay. Is there anybody from the?
Anybody
And
here?
sure, all we got is Bill Griffin, so he's not in a
No.
butter, no?
Okay. Do we have anybody from the public that would like to speak who's not on a butter?
Question.
Okay,
Hi, so I'm Sharon Buffet.
Oh, hi.
Hi. I'm just, so it makes sense for you. You have 3 pieces of property you can't do anything with.
Mhm.
And to merge it into something that you could do something more with would make perfect sense.
Mhm.
I'm just, in understanding zoning regs, what would Ms. Rule be able to do with a 0.78 or 0.75 lot for the future? Would she have to come back because it's still a non-conforming lot, still not an acre lot? And she doesn't have water and sewer. Would she now put a little apartment in that garage if it had water and sewer?
so,
Yes, I can speak to you guys for another variance.
yeah, Sharon, it's a good question. And we can't comment on hypotheticals, but we can say if, the applicant were doing anything that was not within our ordinance, she would have to come back and apply, for a variance.
For building permit
Yeah,
and a certificate of
all
occupancy
those
too.
things, yeah.
That
all those things.
would trigger.
It would have to have a state approved septic, it would have to have
Oh,
like this a whole process, yeah.
Yeah. Okay, so. So I was, a little bit, I was interested in this case. I'm interested in all cases, but I was interested in this one because it's a little bit unique.
Mhm.
And I, needed to, phone a friend. And the friend, we have, the New Hampshire Municipal Association Legal Services are available to us.
Mhm.
And I was a little bit confused as to whether or not, quite honestly, this would fall into the zoning board purview, or if it was a planning board, issue.
Okay,
And so I had a conversation with an attorney named Steve Buckley. And Steve was excellent. If Steve will not comment on specific cases, but he will talk about issues with you.
Mhm.
And what he told me to, he says, you need to look at RSA, and I'll quote it so I don't get it wrong. You need to look at RSA 674:39-A. So I'll be honest, what I did, I went to my zoning book and I said, Steve, there is no 674:39-A. And he says, Dan, that's because it's not a zoning board issue, it's a planning board issue. So please allow me to read what 674:39-A voluntary merger says to you
Mhm.
in the New Hampshire Planning and Land Use Regulation 2024-25 edition. It says, any owner of 2 or more contiguous pre-existing approved or subdivided lots or parcels who wishes to merge them for municipal regulation and taxation purposes may do so by applying to the planning board or its designee. So I said, we don't have jurisdiction over this. And that's,
Sam, man, I thought the issue that we were addressing was whether she had permission to create a lot of less than 1 acre in size. I thought that was the entire point of our purview here today. Not giving her permission to merge
It's
the
an
lots,
area variance.
but giving her a variance of a lot less than 1 acre.
so what is it that which ordinance are we looking to provide a variance on?
Minimum lot size shall be 1 acre. Isn't that what she applied for? R1 district, 401-1.k.
Yeah. So,
So her proposed lot size is smaller than 1 acre, so we have to
It
give a
is.
variance to her. So she can go to the planning board and said, yes, the zoning board said it was okay. May I merge these lots now?
so no, the correct order would say it's a voluntary merger. You start with the planning board. And then if she wanted to put something on it that created, she needed a variance for it, then she would come to the zoning board.
I think,
Or,
I
or,
think-
or the planning board could, the way the statute reads, the planning board could defer to us. They could say, go see the zoning board.
Well, they did.
Because they're our designee.
Truth be told, 6 years ago, they did.
Yeah.
And I'm suggesting to you that was not correct. That was done in error.
I think maybe we could say you can have your variance and and put a condition on it that she must go to the planning board.
There's the,
Because it's less than an acre. I think Bill's right, that it's less than an acre. And that's why she has to come to us, because the
Yeah, that,
lot will be less than
there
an
is,
acre.
there is a concern there is that if you combined all three and it was greater than an acre, I would, like I'm talking this out.
yeah,
Cause it's still less than an acre combining 3 lots, which sounds crazy, but that's what mobile home lots are. They're tiny.
Can I add something real?
Yes,
quick?
please do.
That if you were dividing some larger piece of land, that might be true, that you could not divide it to create a lot less than.
Yep.
What our ordinance says. In the case of pre-existing lots, which are non-conforming size-wise, that this would apply, that you have the ability to merge at will regardless of the pre-existing non-conforming size.
Yeah, I wondered about whether it was if. Can you do it as a boundary adjustment, right? And have the whole thing as one boundary now rather than, is that what it is?
Well.
Cause that was one of the thoughts.
With merging, right? Because now the boundaries are the outer boundaries of all three.
That was my own, I had in the back of my head, I had this question like, is this a boundary line issue, which will be weird, but.
so
Well,
thank you, everybody. This is,
Yeah.
I'm glad we're talking through this. And Bill, I want to come back to you. I think you raised something that I was challenged with as well. There's nothing in this book that talks about voluntary mergers. This says what you have to have, but it doesn't say anything about you can take 3 lots anywhere in this book, put them together and be less than 1 acre. So I don't, we're not empowered to make this decision. And it says very clearly right here that the planning board is.
Well, why would this regulation,
Yeah,
minimum lot size shall be 1 acre.
yeah,
So that only applies then when, as Tiffany said, you have a large property.
yeah,
And you're subdividing it.
correct.
So we handle subdivisions, but not mergers?
We have in the past handled
That
mergers.
doesn't make it right.
No, I agree. And it's not something that comes up regularly at all. Celie and I, between the two of us, I'm struggling to think of the last time I did it.
So let me ask you this.
Remember that case of the well? Remember there was
I do.
that little piece of, like, it was like a 50 by 50 or something?
Yeah.
Yeah,
Yep.
And we had to make a judgment there
Mm-hmm.
to allow that to
Mhm.
change to happen?
Yeah.
You think that was illegal?
Unnecessary
What?
or unnecessary.
Hmm.
The
The latter.
the other part of this is that I guess I would have a question for Rob on is, if you went to the planning board and they said, no, you have a right of appeal to us, am I wrong? On if she went under this provision? planning board and said, I wanna do this, I wanna make it one lot, and they said no.
So I think the planning board would be deferential to what you guys say here
Yeah.
tonight. If you say this is, you're interpreting, that's what I actually also talked to the municipal
Mhm.
attorney, actually a different one, talked to the other guy. And he said that
John.
you guys are tasked with interpreting the ordinance. And if you guys say full faith and confidence, this is unnecessary, we're putting too much burden on a very respectful landowner in the town. We don't need that. I think the planning board would be like, okay. And actually, there are people on the planning board, as you know, that are like, we didn't need to do this. It was one member that said, oh, she's gotta do this. And I've done my little bit of research, talking to the former zoning administrator who's got an office right here. It said in the old days, I say old days, 10, 20 years ago, we did several of these. And I think that the one piece of advice I would give, and I will take your input here tonight and use it going forward. And if I say, as the zoning administrator in the future, we're putting lots together, 2, 3 lots
Yeah.
together as a voluntary merger, they're not gonna be conforming, but it's gonna get us closer. I'm gonna be, okay, let's go to the planning board, we're cool with that. And if somebody disagrees with me, then they can challenge me here as an
That's-
administrative
That's,
decision.
that's kind of what I was getting at,
Yeah.
was that I wanted to make sure that she still had an avenue.
Yep. Yep.
But I'm inclined to agree with you, Dan. The subject matter jurisdiction is an issue here, like, I don't know that we have it. And I think the planning board clearly does.
Yeah.
I also think they could say, well, we defer to you. I
But the
don't
last,
wanna play that, I want her to be able to get what she wants.
and the
timely.
last thing we wanna do is bounce you around.
Yeah.
Yeah.
We really don't.
I
wanna do
appreciate
that.
that. Thank
No, that's, no.
Yeah, no, I get it. Thank you.
We,
But there is a matter of the law, I understand.
exactly. Thank you for your understanding. But the worst thing that we could do is have citizens start saying, oh my God, I want, listen, from there to there to there, we gotta make decisions.
Yeah.
But I don't think this is our decision to make. I don't think it's
Understood.
necessary
Sure.
to make it.
Mr. Chair, I also absolutely agree with what Tiffany said. We have done it. We did it down on Shaker Hill Road. A gentleman wanted, he had 25 acres. And you wanted to carve off a piece of land that had his house on it. And there was sort of a natural boundary from years ago with a stone wall. This was just last year, you may remember.
Mhm.
And it was gonna be non-conforming. He's actually in the R3. So it was gonna be less than 3 acres for the lot. But it was, I think, textbook what she had just mentioned, where that one really does. I mean, you had the option of making it 3 acres there, but he came in and made a really good argument for the specific characteristics of that lot. Where
Yeah.
there were stone walls literally wrapped around the house, and that was gonna be like 2 acres or something, if you remember. And you guys said, okay, we'll give you the variance for that. And I think that is where the variance would be required to let him sort of,
Yeah, this is
Not follow the
this
rule.
is a rare bird that you put 3 together and get less than an acre.
Right.
You're not, I mean, that.
so I think, this is one of those cases, maybe I gave you a quote there that the pursuit of perfection should not get in the way of progress. I mean, we're never gonna get her perfect here. This is a very odd
Yeah.
little situation,
Yeah.
but it's getting better. It's getting a lot better. And so shouldn't that be what we're looking for?
Yeah, I'm sorry, Celia, you were
I
trying to.
just wanted to bring up, non-conforming lots and uses,
Okay.
and I think, that might show a different look at how you look at the
Okay.
merge. And that is that any lot that's there is considered lawful. When the zoning passed, so.
Yep.
If this was there then, which it probably was, that those are lawful lots.
Yeah, no doubt. I don't,
So 3 of them are lawful. Put them all together, is it not lawful? I mean, that's good. She's got a great point. I think that's
Or
probably.
law.
no, I'm not saying it would be
Yeah.
not lawful.
No, I'm not either.
Yeah.
I'm saying
No.
3 lawfuls added together is a lawful, if you ask me. I
It'll be
mean,
less non-conforming.
there you go. That's the word. Yes.
Yeah.
Well, could we? We're saying that she needs to go to the planning board. And you're saying that our approval, our voted approval for her, so she can go to the planning board, would take care of this. I'm looking at the 5 criteria and thinking she meets them all. It would be a hardship if we didn't let her do it. That we could vote to, say that we think it's a good idea. We could make a motion that says something about, we think this is a good idea, and that the zoning regulations say that she needs to go past the planning board.
Like a non-binding resolution?
Is that what, yeah.
An
But-
unfunded
but-
Band-Aid.
To have something official for her so she can continue if we can't grant her the variance.
But why did the planning board, what argument did they give for punting last time she went before the planning board?
That the planning board, one of the members on the planning board is like, we cannot create a lot less than 1 acre in this zone. That's what he said. So
Okay,
you gotta go to
Yeah.
the zone. board.
I didn't even know I was denied. I just thought it fell through the cracks somewhere. I honestly didn't know.
And I went back and looked at the minutes, and it's kind of a funny story because it was actually the first meeting when I started here 6 years ago. It was my first meeting within a day or two of
I
my
can
first day.
guess who the member was.
Yes.
I would love to hear a member of this board make a motion that this applicant's money will be returned. And she is encouraged to pursue the matter with the Enfield Planning Board. It is unnecessary for the ZBA to grant a variance on this.
Is that your motion or you want?
I don't know that I'm allowed to
You can make a motion.
I can make one.
I will second it. How's
I
that?
make that Whitney, I'll read it again. You ready?
To say that
I
we approve of her request
Yeah,
somehow,
excuse me, let me,
so that the planning board knows that we heard what they think and we think it's a good
Let me-
idea for her to merge these 3 lots, but
okay, let me,
I don't know how to word it.
let me repeat my motion.
Please.
I would like to make a motion that the applicant's money be returned and she pursues the matter with the Enfield Planning Board. The ZBA sees it as unnecessary to grant a variance on this issue. And you were going to say?
I think we should dismiss it without prejudice, so that should anything like this ever come back again, it's not that we said, we certainly didn't say yes, but we absolutely did not say no. Just that it's not under our jurisdiction to decide.
My thought is along those lines is also, can we remand it?
I think you can.
I think we can
As a-
remand it.
as
So
a
that
quasi
we
judicial-
tell the planning board, take this. Because we've done it on appeals. People appeal them and we say, this is you, because ultimately. There's this check and balance, right? They make the recommendations for the changes to the ordinance, but we're the final arbiter of it. And I like what Tiffany's saying is that because I seriously would like Rob to have the power to make this call without somebody questioning him in the future. Should we ever see 3 more
Yeah.
0.2 acre lots
Yeah.
get squeezed together?
Unique.
Rob, question, if we were to dismiss without prejudice, would the applicant's money be returned to her?
Absolutely.
Yeah, we
I
can
haven't
do that.
deposited her money yet, so.
That's easy.
Yeah.
We can do that as a motion, like you're saying, in a motion, we refund the money and dismiss the matter without prejudice. I think you as chair could certainly communicate with the chair of the planning board that we believe that this falls under their jurisdiction pursuant to this statute, and that I think sends the signal.
Yeah,
You
I
know
think
what I
they'll
mean?
receive that. I think that will
I-
absolutely be enough to get it to go.
I don't think I think they just need to
Yeah.
know it's ours.
Yeah. All right, so the motion is everything I read previously and that we dismiss without prejudice.
Could you
Would anybody-
read it back?
Sure. Whitney, would you like to meet and read it back, or would you like to? Okay. I make a motion that the applicant's, money be returned and she, pursue this matter with the Enfield Planning Board. The ZBA thinks it is unnecessary to grant a variance on this matter and dismisses it without prejudice. Would anybody like to second that?
That's pretty good.
I second.
discussion.
Discussion.
This case seems pretty cut and dry. But can we imagine a future case where we might want to withhold approval. And by doing this, we're setting the precedent that it is outside our jurisdiction and we are therefore giving up the power essentially to review further cases of this nature.
Good question.
I've got another way to might look at it. What if we ask the zoning and planning administrator to write a letter to the planning board that says something that we discussed it. We don't find it's in our purview. But we think that the planning board, that by this RSA or whatever, but we want the planning board to know that we think that what you're doing is a good idea.
I think that can be communicated without the form of a letter.
May I speak?
Yes, please.
So I see her point too, because when you were saying that the planning board doesn't see it necessary to grant a variance, where
Zoning board.
zoning board.
Yeah.
Doesn't, so to me, that reads like you don't think that it should have a variance,
Yeah.
the way you said it,
There needs to be
Yeah.
a letter that says,
right?
I know, and maybe it's his letter. So that we say
Or like you
that
would,
it
but it's not
says
in your
that the
jurisdiction.
zoning board, that the letter says that the zoning board discussed this thoroughly with the applicant. And we do not feel it's in our purview. But we do think that she should be granted permission to merge these three lots.
Wouldn't that be making a decision?
I don't
If they
think we can do
conform
that.
to
Basically
the
grant
plan.
I would
Well,
like the
well,
language.
No, not if we don't vote on it, it won't be.
But if we don't vote on it, it doesn't.
So I want to come back. Bill put something on the table and then we didn't address it. So let's wrap this one up first. I think I can clearly communicate what the thoughts of the zoning board were to the chair of the planning board.
Mhm.
I don't have any questions that can happen.
Mhm.
I hesitate to put it into a letter for a number of different.
Oh,
reasons.
I understand.
So if you trust.
So
me,
I mean, whatever your process is,
Thank you.
you know,
Thank you. All right, so let's go back to Bill. Bill said, are we setting a precedence?
Hmm.
Open to people's opinions on that.
One thought I had was to tweak the wording, and it might address that too, is to say, we lack primary jurisdiction
And
in this particular case. In this particular case pursuant to RSA, we lack primary jurisdiction. We would still retain anything appellate wise, anything, if you want a building permit and it's under the size and you did a variance, you'd still then you would come back to us.
So how about, talking what Bill said, if we said we lack primary jurisdiction in this case?
Yes, in this case,
And then so we feel that that prevents us from setting a precedent.
yes.
How would other cases be different than this one? In a way that's demonstrable.
Well, in Enfield, every case is gonna be different because of the darn lakes.
I don't know, I mean, I'll be honest, I don't know that you will see small
Well,
ones.
Rob was saying there was previous cases in the old days. I mean, I don't know.
Yeah, but I
Before
think
was born.
combining three
No,
lots to make,
we had zoning and we.
yeah,
we did.
combining three lots to make less than an acre is pretty rare. But my thought would be that if we said it was, again, we communicate that this is the planning board in the first instance. And if the planning board, so what happens is, if the planning board were to issue you a decision and Barbara Jones decided she didn't like it because she's your abutter and she didn't like their decision, she could actually appeal it to us. And so that level of protection is there for both parties.
Yeah, that would be my response to you, Bill, is that the planning board is a body that is going to look at this for its merits and its quality and whether it sort of is suitable or, all those different things.
Hmm.
And they are the ones that approve the merger. They cannot approve it too, if that's the case. I haven't ever seen that. It's sort of the lowest bar of anything that the planning board does.
Right.
It's always considered to be sort of non-controversial, that we're not gonna get perfect, but it's gonna get better by putting these lots back together and they're getting, less non-conforming or more conforming, so,
Mhm.
I think that's to sort of address your concern. I think that's what we've got is the planning board's process.
So in other words, it belongs in their hands and we should,
Exactly.
Well, and
Yeah, please, Shirley.
Bring that other, the non-conforming use. I think that you should all, it's 413, it's on page 57 in your books. And I'm looking at the third paragraph that they've written,
Yeah.
and it says with the second sentence, any expansion of a non-conforming use may be permitted only if approved by the zoning board of justice as a variance.
But we're not here on a use variance.
Yeah, and the residential use
The
there
use is not
conforming.
changing.
Yes.
yes, it is because we
Okay.
put around the
That's right.
trailers.
I think that,
No, those are gone already, but if she could rebuild. She could rebuild the garage on that footprint tomorrow if she wanted to without any permission. That's
but if she wanted to
completely-
do light manufacturing, that might be a different issue.
Right.
Yeah.
It goes
Right.
on to talk about
Okay.
something.
Light manufacturing. We're gonna make widgets and then build.
I just think that's very.
Yeah.
Yeah, this is weird though.
All right, so let's see if we can wrap this up.
Yeah.
Are you comfortable that your issue has been addressed? You are,
we thought
okay.
about.
So, if you could read back, please, the motion. And if we will find an opportunity within what you read back to put in,
We have to amend it.
do not have jurisdictional,
We lack primary jurisdiction.
we lack
in this
primary
particular
jurisdiction
instance.
in this particular instance.
I still.
Wait a minute, wait, Susan, let her go. Go ahead.
Okay, so currently it is, the motion is to return the applicant's fee and that the applicant pursue the matter with the Enfield Planning Board and that the ZBA thinks it is unnecessary to grant a variance in this matter and dismisses the case without prejudice.
So I would have motion to amend to strike the language that says it's unnecessary. The Enfield ZBA lacks primary jurisdiction in this particular instance.
I'm comfortable with that.
And I think that we just take out that section that says it's unnecessary because I agree, there's somewhat of a negative connotation. It's unnecessary. I mean, you don't even need this and like,
No,
she
I'm
does.
comfortable with the changes that he made. Do we have in fact, can we make, Susan, go ahead.
Yeah, you need a second.
I still wonder if a motion is the way to deal with it. I think maybe, that you wrote a letter and called David Frecht and told him what happened. And so that there's some back and forth between the planning board and the.
This, I mean,
It's starting.
we have our attorney online right now, but this
let's-
board acts.
Yeah, let's not go to the attorney.
Yep.
That
We-
is now
we-
Tim's
we have
motion.
to have a
because he
formal
amended it.
motion to do this.
Second.
Well, if that's what, so
Tim-
that's what we'll do.
Tim has made the motion. We have a second. Let's,
And again, I'm amending your motion to dismiss without prejudice.
Now
So,
you need to vote on the motion and then, the amendment and then a vote on the motion.
yes,
so, vote on the amendment. All in favor, say aye.
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 Now, can you, make the motion, does everybody know what the motion is fully? All right, Whitney, you want to read that?
Not sure.
Whitney does.
So the motion is to return the applicant's fee and have the applicant pursue the matter with the Enfield Planning Board as the ZBA lacks primary jurisdiction to grant a variance in the matter and dismisses the case without prejudice.
Right. That's Tim's motion. Do we have a second?
Yes.
We have a second. Any further discussion? Let's vote. All in favor, say aye.
aye.
Aye. Susan, were you and I?
I wasn't
You
I.
and I. Motion passes 5-0.
Thank you so much.
For your time.
Appreciate your time. Thank you.
Good luck at the planning
And we'll
board.
see Rob at planning board.
I think it was.
We're going straight to the next meeting.
No, but it's important.
Mr. Chair, can I just ask one clarifying question?
Yes, please, Sharon.
all that I was gonna comment, wasn't there an RSA that you read out of that book as to why this whole thing took place?
There was.
I would cite that RSA in your motion, and maybe I'm too late in that suggestion, but it explains what happened.
Yeah, I agree, Sharon, but
It's already in the
I
minutes.
think they'll read the minutes. That's what I think.
Sharon, that's what I was gonna say too. It'll be in the minutes, and actually there will be further conversation that'll take place.
Rob's here to communicate it.
But thank you, thanks for that.
I thank you though, Dan, for catching that, because it is important to do it right, and I think we've done this before, Sealy, where we did it and it wasn't. I'm trying to remember, between the dog cage and the water heater and all of those cases.
Hey, Michael, how you doing there?
Good, how are you?
Good, thank you. My name is Dan Regan. I am the chair of the board. We have Bill Finger, who's the vice chair. We have Tim Linehan, Susan Brown, Tiffany Adams, and Celia Arthuro, who is our alternate. And we have Whitney Banker taking minutes, and Rob Taylor hopefully is coming back, but possibly not. We'll find out. So the reason we wanted to get you together with us was the primary reason was we have some changes to our zoning ordinances, and Rob is back now, and we wanted to talk about those. And Rob wants to be involved in that conversation. We want him to be involved in that conversation. And then we also, I know you put together a very brief training document. We'd love to walk through that with you. And then we probably have some other questions for you. His first question for you is, how'd your son make out in baseball practice?
He may be suspended for a week, but we'll see. We'll see what the league says, which is me. I am the league, so we'll see.
Any ribbies? Did he knock one in?
I didn't even let him hit. His behavior was so terrible. So there you go. A lot of crying. There is crying in baseball, just to let you know.
Well, Rafi Devers is probably available pretty soon.
Yeah, it's a similar situation, actually. Yeah.
So, Michael, we're gonna start, please, with the zoning amendment narratives. And Rob, I know you and Michael have talked, and if you guys have worked out. who's gonna
Yeah,
cover
so
what.
I'm gonna give you the little quick background on the zoning amendments that were passed at town meeting in March 11th. As you guys know, the Tuesday voting, we had several amendments on there. And once we get through that, then Michael can go into sort of more of the procedural stuff.
Okay.
But so I sent you guys this earlier in the day. Hopefully you
You
have a
did.
copy. There were 4 articles that passed at town meeting with pretty much overwhelming support. I mean, it was 3 or 4 to 1 in terms of the vote tallies. Article 2 changed in the R5 zone. That will allow you to have essentially a duplex on an R5 zone. The acreage requirement stands, so that means it's R5 to create a lot. You have to have 5 acres in the R5.
Mhm.
That allows you to have 1 house, okay, 1 residence. You can have ADUs, we'll talk about that in a little bit longer. But you can't have a duplex at unlimited square feet. So if you wanted to have something, it would be an ADU, unless you had 10 acres, then you could have the duplex, which is the 2 residential uses on that lot. So that is new. You could not have a duplex on R5 previously. And the planning board, to their credit, had sort of heard from several people with very large lots in the R5, and it was multi-generational kind of requests where people are like, my mom and dad have a place in Florida. I'd love to put up a place for them so they could come up and stay. And at that time it was 800 square feet max on an ADU. So they felt this was a good sort of housing related change. And we did a lot of work through a HOP grant last year, and that's where they came up with some of these ideas.
Duplex is defined as one building that contains 2
2
residences.
residences, correct. They have to be attached. They cannot be separate houses. You can't have a house here and a house there.
They've got to be attached.
They've got to be together. That's correct. That's the definition of a duplex. So you can have it. So there, I mean, we felt comfortable. There was some talk about maybe going to a triplex. They said, I think that's a bridge too far, kept it at 2. again, you can kind of drive by a duplex and not really know if it's a duplex.
Well, if you have a duplex and an ADU, like, think about it, that's
So now you can't, what you just said, you can't do.
really,
ADUs are not allowed where there's a duplex.
okay,
ADUs are only allowed where there's single family home.
Yeah.
And the ADUs have no acreage requirements.
right,
Maybe I'll touch on that. That's the next one down. Article 3 was accessory dwelling units. As you know, we allow in Enfield, you can actually have 2 ADUs on a single family house lot. And again, acreage is not a concern, but septic system is. And they actually changed the wording here. You'll see they bumped up the square footage, which was limited at 800 square foot max for an ADU. They've taken it to 1,200 square feet. So you can now have 2 1,200 square foot ADUs on your property if you have a single family home. And I'll get a little bit in the weeds here. One of them may be detached, but not both of the ADUs. You can't have an ADU over there and an ADU over there. You can have one ADU over there, and if you want the second ADU, it needs to be internal or attached to the main dwelling. Okay, you can have 2 ADUs attached or internal in the main dwellings, which basically becomes a triplex. It's essentially a 3-unit house. And then the one other change that they put in here, you'll see, is that the old law, and actually the statewide law right now, says that if you want to add the ADU, you have to have the septic system capacity design approval. Meaning you go to the state with a licensed designer, they design you it, you sort of hold it in the bank, but you can build so long as the existing septic system will continue to support the added load. The planning board did not like that, and especially given our recent experiences here in Enfield with septic, we're real serious about trying to make sure that every house and every unit has a substantial, approved septic system on it. So now the requirement is if you're going to build the ADU, you have to build the approved septic system with it. And so that's a big stumbling
Yeah.
block for a lot of people. And
yeah,
you could tell why the state had mandated it originally, that they had said, okay, we'll let you, as long as you got the design sort of in the bank, so to speak, that if you need it, you can pull it out and build it. If your system starts to fail or something goes wrong, you've got the design approval. And that was kind of the giveaway to the housing, crisis, and people want to
Yeah.
make it easier for people to add housing. But the planning board, to their credit, if you're on that side, or maybe to their not credit, they said, no, you have to build it. And again, that is a stumbling block because it's a huge expense to add a septic system, as you know.
But it's reasonable because
Yeah.
of all these lakes with these little tiny
Yeah.
lots.
You're right on it. And the other thing is, if you're in the sewer system of the town of Enfield, municipal,
you're good.
you can hook up. You're gonna have to pay some connection fees for additional bedrooms and so forth. And then there is Lebanon hits us with a development charge for additional connection for their system. And that's been a little point of contention between Enfield and Lebanon. But their argument is, when you hook on a sewer system to a house that's going to Lebanon, you're sort of getting all the benefits that were offered from all the previous people that paid to get the thing started. Why should you be able to come on and not have to sort of ante up? It's very similar to electric. When I built my house, you hook onto the electric system. They don't just charge you the sort of, hardware of the transformer and the pole. You have to basically buy into the system as a sort of development charge with electrics. So that's not without precedent. And that's what we've got.
Hey, Rob, there's
Yeah.
another couple minor variations,
Yeah.
on 422, accessory dwelling units, number 3. Couple of things have been taken out. One was, it used to say, DES approved for properly sized new on-site sewage disposal. The word new has been taken out. And then it also used to say it must be installed by a licensed professional. That has now been taken out. So,
Yeah, so they thought those were unnecessary, both of them. The septic system law is state of New Hampshire law.
Hmm.
And they just felt it was unnecessary for us to tell anybody in terms of how that goes down, that you have to work with DES, you have to work with their licensed professionals. That sort of is given. And it's not something we need to remind you of in our zoning ordinance. So they
Okay.
felt that was,
and before you move off of ADUs,
Yep.
the other thing they provided is a definition of conditioned space.
Yes.
So that didn't exist in
Yeah.
previous versions.
Yeah, and that's actually in the state law that they do discuss that. And we felt that it was good to put it in there as a definition because, you know, it comes up a lot, you know, like if you have, over the garage, you know, you got the roof pitch and then there's knee walls. And that space out underneath the knee walls is cold and unheated. It's storage space you can use, but we're not gonna count that as the square footage of the ADU. Similarly, an unfinished, unheated basement would not calculate up if you wanted to set a future ADU on a foundation, a full foundation. So we did try to come up with that. That's what that is. The conditioned space is part of that update that we did. And it really defines it as space that's heated mostly. There's not, I mean, there's obviously some people that have air conditioned space in the summer as well, but it's basically that space or envelope that's conditioned.
Okay.
Yep.
Thank you.
So moving on to the article, the fourth one, parking standards. We had, from the legacy of amending the zoning ordinance, you know, 30 times in the last 35 years. We were sort of all over the place, and this article that we adopted at town meeting this year tries to standardize it.
Yeah.
The state is actually working on this. We may actually, and this is maybe a discussion for later, we may be getting some statewide zoning from the legislature. They're sort of pushing to make towns not be so hyper-focused on parking. And I would tell you that planning board has sort of realized that as a sort of trend in the land use realm, that we shouldn't be so overly prescriptive of, you gotta have all these spaces. And again, it's clear that it's part of the housing problem is, it's like, you build an ADU, you gotta have 2 parking spaces. Well, if there's only 1 person living in the ADU, why do we have to have 2 spaces? So they try to do some work on the parking standards to standardize what's the size of the spot. They did actually give you a smaller option. If you're really tight on space, you can go, right now it's 10 by 20 is the standard parking space. If you want, you can actually use 9 by 18 in certain circumstances. I think their opinion throughout this was, it really, I mean, if you're trying to rent a place and they don't have parking, that's between you and your potential landlord. It's not really so much of our thing. And I would point to, you know, Lebanon is a great example, is that when they built all those plazas in West Lebanon, they way overshot the parking requirements. So you have these massive parking lots that are 90% empty, 364 days a year. And so that's a sort of a planning mistake that people have made in the past. So sort of backing it down, kind of let the market dictate a little bit. Obviously, we'll have minimum standards, but we're sort of relaxing a little bit. And I think it's gonna come from on high too.
Landing pads on the roof.
Exactly.
We go to, so, yeah.
And then,
Like,
just real quick, I know we got Michael on the clock here, so I want to get to him. The last one was the CB, the Community Business District. We sort of basically fell in line with what we have currently for R1. If you remember, a few years ago, we changed the acreage requirements for lots that have municipal sewer service available. We thought, if you can do it in the R1, why can't you do it in the CB? So that has come very much in line. It's obviously in the R1, it's 1 acre minimum. Unless you have the availability of municipal sewer, you can go down to a 1/4 acre in size, which I'm kind of proud of because that's encouraging infill where the services are. It's kind of a trend in planning and zoning. It's not without controversy. People that live in the R1 or the CB are like, we don't need more houses, but that's where the houses really should go because that's where the services are. We've got sewer and water service. We've got public transportation, we got high-speed internet, all these different things where the housing really should go. And so we did that little adjustment so that basically the CB zone mirrors the R1, that you can take it down to a 1/4 acre in size. Because it's very similar. I think the CB and the R1 are sort of in similar places. Obviously, CB is right along Route 4 there in the downtown area.
Okay, thanks.
So that's it.
Hey, Michael, I'm assuming that you are somewhat familiar anyways with these changes. Anything as a zoning board that you think we should have on our radar screen, be aware of, or consider? Anything at all?
No, I think the changes are good. I think what we're really gonna be looking at the next couple of months is what the legislature does. I think we've all heard grumblings about significant changes to our authority as a town to regulate our housing. Really, it's all aimed at housing. So I've heard of some pretty drastic state statutes that are working their way through. Obviously, we have no idea. I don't know if Rob probably has a better understanding of where everything is in the legislature, but that's the thing we're going to be looking at, probably things coming in September, October, likely, or maybe they're coming in now, but buckle up. We'll see what happens. I think we're gonna see some significant changes, which may handcuff, what we do and what we can allow and not allow. Rob, do you have any idea of, nothing's passed yet, right? It's still,
Thing has passed, but it's actually, I believe, tomorrow coming up for,
okay.
a lot of them have come out of that housing committee with basically a unanimous recommendation of these committees, which bipartisan. And so it sort of makes them a little more streamlined in terms of the final vote. It's sort of a consent instead of a big debate if it goes out of the committee with a unanimous recommendation. So I know the municipal association, of which we're members of, is very, very concerned about this because it really does take a lot of local control away from us and sort of sticks us with what we get. And there's several, as Michael was alluding to, several that are proposed. I could send you the municipal association update onto what they're proposing, but it's a little scary because it really does.
We'll cross that bridge when
Yeah.
we get to it. Let's not spend a lot of time on it tonight. Does anybody have any questions or comments, thoughts on these latest amendments?
Needs.
Okay, let's move on. Michael, can you first of all take us through, you don't have to go verbatim here, but just what it was you were trying to impart on us with this memorandum, training 101.
Yeah, this is just a standard memorandum I present to my boards. And by the way, my name is Michael Courtney. I'm from Upton and Hatfield. Represented the town with Jim Raymond for a while now. We had an appeal just this past fall that took us to the land court, which is now in Manchester, New Hampshire. And when someone appeals a ZBA decision, we now go to the land court, which is actually 2 miles from my house. So it's nice for me, not so much for you. And I clerked there when I was younger. But yeah, so what I'm trying to do is get each board member to understand that when you make a decision, what happens after that, or what could happen is someone could appeal, and why it's so important that the decision you make is factually sound, it's clear, it's concise. Because a judge, when we go into court, the judge is going to say, okay, what did the board do? And I don't have ZBA members testify. We just look at this giant certified record, and we're really just looking at the meeting minutes. So it's critically important that board members make factual findings in the record. They, if they're relying on an expert or report, they cite to that. If they have experience with this area, overcrowding or traffic, that they make clear, yeah, I've driven by this area every day for the last 25 years. I understand that this is sight distance is an issue, things like that. Because the judge is just looking at, it's an appeal of your decision. So you're not testifying. So all I'm trying to do in the memo is give a overview of what we're trying to do and what the court's going to look at as to what you're doing. So the first section is evidence before the board. You are a quasi judicial board, but you're quasi in that you do have some legislative powers. But when you get an application before you, you're just like a judge. You're weighing evidence. You're not going out there and finding the evidence. You're having the applicant, the abutters, the public present to you evidence. You're not going out, you're not talking to the applicant outside of the meeting. You're not talking to, the realtor outside of the meeting. You're just, who's been to court before? Who's had a case or been a juror? Has everyone been to court at some time and seen the process of the judge?
Sure.
Yeah.
Yeah. So you wouldn't want your judge going out talking to the other party or talking to another witness outside of the courtroom, right?
Right.
We wouldn't want that. So that's why it's important when you're sitting as a ZBA member on the case, you're finding the evidence, but you're weighing the evidence. You're not going out and finding the evidence yourself. You can certainly rely on your experience, as I talked about. Yeah, I know this area, it floods every spring. It's really a unique property. Sure, you have that experience. You can rely on that. But you're not going out and talking to the people. You're not doing your own little site visit. You can't do any of that because you wouldn't want a judge to do that. You have to remain impartial. Same with you wouldn't want to talk to each other outside of the meeting. You may say, well, it's not a meeting if one member is talking to one member because it's not a quorum, but then that other member talks to the other member, and now you've created the wheel and the spoke where now you do have a conversation, you do have a meeting. So you really should act as a judge when you're hearing the evidence before you. And if you need to continue an application because you want to deliberate more, that's fine. We usually have a rule that, I don't know if you guys, I looked at your rules of procedure this morning. I don't remember if you had a rule that you cut off at a certain time, do you?
No.
No.
Yeah, it's a good idea. I don't know if you guys have some late applications lately, but usually after 9:30, 10 p.m., there's some pretty bad decisions being made, and you get pretty. I guess that's it in all aspects of life.
Hey, Michael,
So-
could you go back to talking to each other outside of the meeting for a second? We live in a very small town. We see each other in the supermarket, on the streets. You're not saying we shouldn't be talking to each other, just about a case, correct?
Yes, of course. If you can talk about the clam bake or the potluck supper, sir, certainly. You can't talk about a subject matter of a case, an application.
Can we talk about things that happen in a ZBA meeting outside of a case, such as rules of procedure, let's say? Hey, you know
So-
what? That was a good idea that Michael had to add that into the rules of procedure. Maybe we should really, what do you think of that?
Sure, absolutely. You can, and that's part of when I said quasi judicial, you do have some legislative powers, to propose zoning amendments. So certainly rules of procedure is not, you're not violating anyone's due process rights by talking about that. We want the application to be fair for the abutters, the applicant, everyone. We don't want to tip the scales. But if you don't have an application in front of you, you're not violating anybody's rights, or you're not being biased, or you're not doing an ex parte communication. Certainly, yeah, talk. But remember though, can't talk as a quorum, right?
Yep.
So, yeah,
So one
rules
more
of procedure. Go ahead.
One follow-up to that, I'm sorry. Can I, as a chair, send out an email to all the members of the zoning board in a blind fashion that says, hey, at this week's meeting, we're gonna be talking about X, Y, and Z? Just to give you a heads up, we're gonna be talking about fees. We're gonna be talking about rules of procedure, et cetera, et cetera. I don't talk about any cases. Can I talk about that?
Yeah, just make sure no one turns it into a reply at all.
Well, they can't, 'cause it's
I know it's BCC. I know. I'm not a tech savvy guy, to be honest with you. But I've litigated right to know cases, and I've seen these firms claim that we violated the right to know law, but we blind copied, and I didn't understand how then someone turns it into a reply all. But just be careful. If you copy everyone, you don't BCC, but you CCC anyone. If someone replies to it, the thing you do to cure that is just shut it down. Judge is never going to say, oh, they replied all, you guys are violated. If you've put, if you responded to that, say, whoa, guys, stop. We'll discuss that at the meeting. No problem there.
Do you have any follow-up questions? Do you have any follow-up questions to that? That's different than what you said earlier.
My understanding was that it didn't say you can't, you shouldn't do it. You really shouldn't, because if we get hauled into court, it can become a problem. We have to be very careful because we don't want to get hauled into court. And on some of these really difficult cases that we've had, it really.
That wasn't the issue. What you said was we can't do blind copy to everybody on the board,
Well,
not.
but what I did say was, you can give it to Rob and
Yeah.
he can send it to everybody, but we shouldn't do it. Rob should do it.
So I think what we just heard was different from the lawyer. Let's go with what the lawyer recommended. Thank you.
Can I just so we're on the same page here? The hypothetical that was given to me was not about an application, but it was rules of procedure. It was about, what else did you say? It was rules, A, B, C, or
Fees.
X.
Covering fees, we're gonna be
Yeah,
talking about
yes.
color jackets to be, that's, yeah. What time the meeting?
So agenda
will be.
items. It's
Yeah.
just that you're trying to set up the agenda. Yeah, I mean, normally Rob, you is a good source. We want the planner to, I don't know if, I think, I'm just using planner as a general term. People have so many hats in all the towns I represent. It's tough to remember who's a planner and who's, what the titles are. But it's usually good to have that one person, not a board member, circulate the agenda. The chair can work with that, but where I get certainly uneasy is if it's an actual application, then don't talk about that at all. I've had where the chair sends it out and it's kind of how he's saying it is basically, you should do this with the application, or I don't believe the credibility of this expert. And now you've tainted the whole thing, which you guys aren't going to do. But that's just a pitfall I see. One other thing I really do want to talk about, and I see it every year, is everyone on Facebook? Who's on Facebook? Yeah, okay. Well, someone always comments, and it's usually in a good spirited manner when some public member is talking about an application, and I have a comment from a board member saying, just to clarify, this is what really happened, or we understand your concerns. Anything very innocuous can be turned into bias and you'll be disqualified. The case will be possibly overturned. So just do not comment on any application on Facebook. Really, it's for your mental health to get off Facebook altogether, but that's not my area of expertise.
Okay, thank you. I'm sorry, I
Even-
took you a little bit off course.
No, but even if you like something, that will disqualify you.
Yeah.
No liking.
Hate everything and everyone. That's what I heard.
Yeah, okay.
We're never discussing this kind of stuff on Facebook. It's too damn public.
Does anybody have other questions for Michael other than things he's already covered or clarification on things he's covered?
Can you back up to the site visits that you mentioned a few minutes ago? You were saying that in the gathering, what you're gonna say in the meeting or what knowledge you know of something. And you mentioned something about going to a site visit.
Yeah, oftentimes we get an application and board members will decide, I'm gonna go and check out the property. And then they speak to the owner of the property, which is the applicant. And now you've created ex parte, and you really shouldn't have done that. And it should be a site plan as a board where you have meeting minutes, which says, the board arrived at 8:04 a.m. You're not at the site visit. It's actually just like in court. When the court takes a site visit, all the applicant is doing is pointing out geographical things like, this is where the wetlands are. This is where the setback is. You're not asking about, surrounding property values, stuff like that, the variance criteria, the special exception criteria. You're just looking at the lot. But if you go out and drive yourself, you're really putting yourself in a vulnerable situation because someone's going to approach you. Or an owner could even say, you could say at a meeting, yeah, I went out to the site. They're going to say, what, you trespass? Like, it's a terrible idea to go out and visit the site. I know you guys, live in the town, you know where all these properties are and you're all neighbors. And it makes sense to just take a trip over to, Mr. Smith's property, but it really should be formal. It should be documented in the minutes, because then when I go to court, the court's gonna say, oh, they went on a site visit. Here are the meeting minutes showing it. Then the plaintiff argues that the chair went by himself and had this discussion with the applicant saying he thought it was a great proposal. And now we have a factual dispute, which you actually may have to testify in court as to that, or you may be deposed. I've never seen it. We've never had discovery in these ZBA cases. We've been pretty good resisting it, but I wouldn't say it could never happen. And if you just don't put yourself in a vulnerable position, where it's your word versus theirs, or go ahead.
Can I ask you a question?
Of course.
I need to see things in 3 dimensions, so I like to drive past without stopping or talking to anybody. Is that okay? I never stop.
Yeah,
and talk.
Sure. If you can drive past it. You probably know the area. You probably know all these lots or have a good idea. It's when you physically stop the car and you do a real site visit where you get out, step on the property. Once you step on the property, I mean, if someone steps on your property, you're going to say hello to them. So if you're just doing a drive-by, sure. But the site visit I'm talking about is stopping the car, walking around. Yeah.
Well, I haven't lived here this long enough to know all the property, so I drive past, but I don't stop, and I never talk to people.
I think that's fine. Just don't go any further than that.
Okay.
Okay, other questions?
Nope.
Tim, Bill, anybody?
Well said.
Everybody said? Rob, anything else you think we should cover with Michael?
That's all.
We have had discussions here, Michael, about the findings of fact. And there was a law passed maybe a year or two ago about when we do our official decision, that becomes sort of the formal record of what took place here, and that the chair signs, that they want reasons in there, and so just comment a little bit on those sort of documents that go along with the case that become part of that certified record for you and that end up in court. Just tell us a little bit about what you'd like to see in those.
Yeah, that's a great point. They did change the law recently, and findings of fact are critical. They should be part of the notice of decision. And in the olden days, we would just comb the meeting minutes and cobble together some words, some statements people made and say, oh, this is what the board found. But now we need the board to make affirmative findings. For instance, if it's a variance, the board would find, you guys want to all together as a board go through the 5 variance criteria. For instance, the surrounding property values one. You'd want to say, the findings of fact are, we found that the surrounding property values would not decrease because they presented, and then you state what the criteria is, and then you want to actually find the facts that support that criteria. So for instance, we find that the surrounding property values will not diminish because the applicant presented an appraisal which was credible, which showed that this variance would not affect the property values. Furthermore, we found in the spirit of the ordinance that this would not increase traffic, and because it's not increasing traffic, therefore it wouldn't reasonably decrease property value. So you want to take it a step further. I don't know if you guys do that now in each criteria, but you want to explain, yeah, the criteria is met and this is why. If you don't have that, if you don't do findings of fact, you deny an application, that is grounds for a remand back to from the court back to the board, where the board has to have another meeting and find facts. And I had to do that just last fall for another town because it is a new procedure. So that's, go ahead.
I'm sorry, should we be doing finding of facts and going through each of the criteria, or is it both of them we should be doing?
The findings of fact are relate to the criteria. So you say, this criteria 1 is met. And you
Yeah.
list the criteria, and then you say because, and then
Yeah.
these are the facts. Like, for instance, hardship, it's a unique property because there are wetlands in the back, or it's a large parcel based on the tax map, things like that. So you want to just color in, the decision that way.
Got it.
It makes my
Thank
life
you.
so much easier on appeal when you do that versus me having to cobble together, this person said this person said this, and I only have 2 people saying 2 different things. I don't have a quorum finding facts. So if you guys can get together and find those facts as a board, then the court knows, oh, this is what they found. Certainly.
Okay. Got it. Thank you.
Anything further from Michael?
No,
No, sir.
I want to add one thing about how you interpret the zoning ordinance. It's a legal question. One thing I would say you guys always want to have with you, you always want the zoning ordinance so you can see if a term is defined, because if the term's defined, use that definition. But oftentimes a term isn't defined, and courts rely on the dictionary. So if you have a dictionary with you, you can always go online. I think dictionary.com I think I use that actually in my legal writing. But a dictionary is a great tool to have with you. I don't know if you guys use that, but I had a case just this last year where, believe it or not, the question was, what did the word commercial mean? And you'd be surprised how many people think it means something different than the dictionary definition. And the court ultimately usually refers back to the dictionary definition. So that's one tip that I would ask that you all, think about having a dictionary with you. That's just one thing that might be helpful. Any other questions?
No, sir.
Okay.
Good
Thank
luck.
you so much, Michael.
Yeah, good luck getting your son out of the clink.
Yes. Yes.
We're going to keep them there for a while. Thank you.
Yeah.
Have a good night.
Stay, hope to see you soon, but we don't hope to see you soon.
I understand. Take care.
Thanks, Michael. Take care,
Yep.
man.
Bye-bye.
Yeah.
Where's he from?
Upton Hatfield,
Manchester, Upton Hatfield is the firm.
Oh, okay.
Said he lives 2 miles from
which is,
the,
what's really ironic is he's with Upton Hatfield and is our attorney. And yet those guys actually work for Drummond and Woodson. And they're like competitive firms at each other.
Yeah.
But I think it's definitely good. Maybe I need to write a warrant article that says, shall the town vote to adopt Webster's 5th dictionary as the official thing? Just to really get town meeting riled up, but cause I'm like,
It's already rounded up.
Use the Oxford English, it's longer.
yeah, can we get one of those ones that has a table? With dust that comes out when you turn some pages.
All right, we've got 8:15. We've got no more cases, but we have a number of things to get through. So let's try to be thorough but concise. And let's start with the minutes from April 8th.
I could not find a single typo. Not one.
Okay.
I tried.
No, it's almost, I kind of go, there's not gonna be anything here. Whitney does it right.
There is one on line 294. It should be SIT citing, not SIGHT citing.
Huh?
line 294.
For what
They
is it?
said that they would have
Location.
into citing the building more appropriately, so you have to use SITE,
Oh,
SITING there. I did find one
That is-
mistake. But I think we
Should-
need to talk, and I don't know if we can we talk about the findings of fact that
Can we
appeared in the minutes?
Continue going through to see if people have any changes first, and then we can try to have a conversation about that.
That was the only thing I found.
All right, I have 299. Mr. Regan asked if the lot was in the same condition. I think we then need to insert when purchased as it is currently in. Draft the condition when purchased as. Then I have line
I was gonna say,
393 and 394.
would you say what you said for 299 again?
299, Mr. Regan asked if the lot was in the same condition, insert when purchased as it is currently in.
Oh, that's better,
so that's what he said. I,
yeah.
All right, I'm sorry, 393 and 394. Starting with 393, the small size of the lot makes the specific development sought by the plaintiff impossible without the variance. We're talking about variance there, not a special exception. So you're gonna insert specific, please, before development,
Mhm.
and then variance instead of exception at the very end.
Got
Line 530, and I think you do a wonderful job too, and it's a little bit, but, that's, why is finding of facts in red?
Oh, that's from my template. I just didn't
Okay.
change it over.
Good reason. And then 538, this is a question you could answer better than I can. We use the word plaintiffs. Is that what we normally use, or do you use applicants?
Normally I use applicants. Those were just directly from the notes that Bill took. But I can change it to applicant.
Why don't we go with applicants if that's what we usually use? If that's all right with you.
Good news, you.
All right.
I can do that just throughout.
That's all I had besides, the discussion of findings of fact. Pardon me?
Yeah, is promulgated the right word there? Justice is promulgated? Justice is
served.
served? Yeah, that'd be better, wouldn't it?
Done. It's,
It's in line 538 again. Justice is served
Your word, so you can address
instead
it.
of
Yeah.
promulgated.
was looking up the definitions of the reason.
I would think promulgated isn't quite what you mean.
Bill's got the dictionary out for the record.
Promote or make widely known an idea or cause.
Yeah, I think you need to say served.
So it means more advertised than it does serve.
Yeah.
There you go.
When you go without,
Yes.
thank you. Any other changes besides finding of facts?
Oh, do we have 3 sets of findings of fact? Because Mr. Kelleher had 2 applications. There's findings of fact, line 243. That's the one about the apartment building, right?
If the finding of facts can be the same
That's for
for
Mr. Kelleher,
both, his special
Okay,
exception as well as the variance.
yeah.
Yeah, I mean. We don't need the 5 criteria for that special exception. So it could be there.
Yeah.
And again, it's more, really more important. You hear this over and over again, that when you're denying it, that's when, you know, if if you grant it, generally speaking, no one's gonna complain.
Nobody's gonna complain. Mr. Kelleher did not appeal.
So going forward, we will definitely do finding of facts and the criteria
I
on every
see.
single case. Excuse me, I was in the middle of a sentence. But I was encouraged to hear the lawyer say, you're saying what the facts are in the, when you're addressing criteria. That was good. So
Yeah.
I, again, will apologize one more time to this board for having made an error. But I think it was corrected and it'll be corrected going forward. So I'm good with what's in these minutes.
It was also
We're all
late.
three there, and that's
It was late.
It would have been another half an
Yeah, that
hour
was
of
fine.
chewing instead
at the
of
bottom of the page.
listening.
Can we make a motion to accept these minutes?
I make- Yeah, there you go.
Tim made a motion, Bill seconded. Any discussion? All in favor, say aye.
I,
Whitney does an incredible job.
All right, new business, ZBA fees. Let me just give a couple of quick sentences and I'm gonna turn it over to Tim, where's his idea. And Tim, thank you for raising the idea. I think it was worthwhile thing to be discussed. I did first look up to see where do we get the right to change fees? And what I found was RSA 673:6, staff finance fees handbook page, numeral 3. -10 and RSA 676:5, appeals to Board of Adjustment handbook, Roman numeral 3-11. Mr. Taylor, I have a couple of questions for you.
Yeah.
It says clearly that the ZBA fee schedule should be currently published in a location accessible to the public during normal business hours. Is that the case?
Yes, it's on our website.
Okay.
Yep.
And it says, the current schedule was updated in January 2021. To the best of your knowledge, is this the most up-to-date schedule?
Yep.
And was January of 2021 the last time this topic was discussed?
Yes.
It was. So we're over 4 years. So I think it is well worth to have the discussion. And Tim, I'd ask you to please take the lead.
Sure. So this just occurred to me because I was around when we did this before. And given that costs have gone up, even just to operate the board, Rob's salary has gone up, right? That's largely our budget line item. It's not the marvelous chairs. We don't pay for those. But I will say that, kind of looking at that and saying, where are we at? And having been, I'll be honest, having just been through the legislative budget process in a tiny little state agency that I help run. A lot of this, where can you get money from, came to my head. And so I looked around and saw where where our neighbors were kind of at. Of course, Canaan doesn't have a fee because Canaan doesn't have zoning, really to speak of. Lebanon is $250.
300.
Where?
Is it? Is it now? Because Hanover is 300 and when I thought I saw it as 250. So
Are the numbers in here that they charge?
Mhm.
Where are the numbers?
On the website.
Okay,
The numbers that we charge,
yes,
I can tell you right now, so $150 for the hearing fee.
Yep.
We charge $8 per abutter for the mailing.
well, that's just postage.
it's,
Well, it's a little bit
Oh,
more.
thank you.
So we do add a little bit to the certified, is like $5.51. And I've seen a lot of communities that's all they charge. It's just a pass.
You need to have.
There you go, $5.54.
I'll cut back.
But that doesn't
Yeah,
count
isn't it kind
the envelope and the time. and all that
Yeah.
stuff. So we made it $8 and it's standardized across both you guys and planning for the
Okay.
butters fees. Nobody blinks an eye about $58. And then we also have the $75 newspaper of record advertising fee. We place an ad in the transactions in the back of the Valley News, which is sort of the low cost version. I do know that you guys must spend a fortune on advertising because they put
Concord.
block ads in the
Thank
front
you.
sections. And our fee, $75, right on the edge of covering what it is.
Yeah,
It's
and that
$69.
was the one that we updated before I believe, was,
Yeah.
that was the advertising fee, because we were losing money
Yeah.
on that at one point.
I keep an eye on it. We're pretty good,
Yeah.
especially if there's multiple hearings, then we take advantage, obviously, of sort of discounted cost of placing an ad for multiple hearings at
So,
once.
so we, though, that's kind of, I mean, but the overall, my thought, the big fee in this is your application fee.
Yeah, the hearing fee.
And so Hanover's 300 and Tiffany's telling me Lebanon's 300 now.
Correct.
Grantham is 200, but Grantham is not, well, one of the big distinctions I have with Grantham is that they have this whole housing development that essentially has its own rules that go way beyond zoning, you know, thou shalt not paint their house blue. That's Eastman. I mean, you can't cut a hedge without
Yeah.
approval. So we're at 150. And my thought was that at least have the discussion about, should we be closer aligned to our other municipal
And I
neighbors?
sent you guys the spreadsheet. You got that spreadsheet?
Yeah.
That I did a little survey of several towns and even went outside of our sort
I
of
saw
upper
it.
valley and
It
gave it
just-
Keene and a couple others. I
Yeah,
definitely would say we're on the low side now of those fees. We
Yeah.
were, before we changed it to 150, we were at 75. So we've
yeah.
come along slow.
75, you pay for ads by the number of lines, right?
Right. The transaction act. Yep.
Yeah, so is 75 enough for an ad?
Yeah, I just told you earlier that I keep an eye on it because as soon as I place the ad with the Valley News, she sends me an invoice. And so I look at it. Is it close to
Not even
75?
printed yet.
And it's
Here's the
usually
bill.
pretty much right there. Again, if we have 2 hearings on one night, the ad will be $90. So we make money on that night with
Yeah.
the $75 per.
Oh, I see.
So,
I see.
so just to sum up, I think what I was really looking at is, you know, is the fee going to be overly burdened for your person that comes in here for an application? And I could remember one time when we waived the fee because it was somewhat burdensome. Or we might have even refunded it rather than waiving it. It's before your time, believe it or not. It was for a sign by the dog park. And because they were a nonprofit and everything, we kind of decided, okay, we don't need the fee for that. So we still have that power to waive it if we so choose, but I've never heard anybody ever complain about the cost to file, because if you think about what you're doing when you come in here, you're gonna build something or whatever, that is, you know, that's not gonna cover anything, so they don't really complain about it. My thought was that while we may not be Hanover or Lebanon, we're closer to them than we are to a lot of the others, and we're half of what those 2 towns are. And so
You have a number in mind?
I was thinking 250, honestly.
That was a number that occurred to me as well.
It was like just a slight notch down, because I would say Hanover, Lebanon have these commercial things we don't have, and, you know, not as much in Hanover, but ironically, Hanover gets appealed a lot. A lot.
So Tim, when you're saying 250, you're saying 250 for the fee
But-
plus the advertising.
Plus
cost.
yeah, I wasn't aware that we were that close on the advertising. But you, I mean, this is the thing, you keep an eye on it. The other thing is that, you know, we do have the authority to do it. The last time we did this, I think what we did was we sort of said to the select board, we'd like to do this pursuant to blah, blah, blah. And it was they just went, yeah, sure, because we're giving them more money.
So we don't need to check with the select.
We
board.
we don't need to. I think we did it just because,
Courtesy.
I don't even remember, but it was something along those lines. But I can't see that anyone would have a real concern about that at the next level up. What I did ask was that, you know, I went to, process wise, just to fet this out. I went to Dan in an email and said, hey, would you mind putting this on the agenda? And from there, and I think that's okay. I think that's an okay communication. He's the
Absolutely.
chair. and this is, but this is a ZBA decision.
Yeah.
On its whole, and I think, you know, the idea is it comes from him that, hey, this, we're gonna talk about this.
In motion?
Yeah, I could do a motion.
I have a
Let's
quick
do a motion.
Oh, wait,
When there's a butters,
So why don't you make
we
your,
don't change that.
Yeah.
why don't you make your motion? We'll get a second and then we'll have discussion.
Yeah, I make a motion to, raise the filing fee, the application fee to $250.
Second.
Okay, so let's have discussion.
I'd rather see it go to 200.
Okay. Why?
Cause I couldn't afford it if it was 250.
Okay.
There are a lot of people in town who have piles of money and third and second homes and this, that, and the other thing, and they can afford it. But there are also a lot of people in this town who have to use the food pantry.
But are they gonna
And
be coming to the zoning board?
Think about everybody in town, and I think that maybe 200 would be more reasonable for some of them than 250.
Okay, thank you for that.
That's why I think of it. Somebody in town told me that we don't need a food pantry because nobody in Enfield's hungry.
Susan, let's stay on topic. Thank you for that. So I heard everything you say and thank you for that. I think that's only one piece of the equation, however, is comparing ourselves to other towns.
Yeah.
So from my point of view, I look at a ZBA fee as it shouldn't be a revenue source for the town. Nor
No.
should it be less than what it costs the town. Because if it's less than what costs the town, that means we're asking all the taxpayers to pay for it.
Right, and I think even at 250.
Yeah.
We're below what it costs.
So I did some work on this
Yeah.
and I asked Rob how many hours he put in. I asked Chantel how many hours she put into the average application. And let's say that's Rob's salary fully loaded. So after we pay
Yeah.
Rob his salary, his benefits, his health insurance, all that stuff, it's $50 an hour, just say, that's directionally correct. Chantel's about $35 an hour.
What about Whitney?
Whitney, I did not count. Let's assume that we put it in there. It's in there somewhere.
Yeah, it's,
But so if Rob did 3 hours and Chantel did 2 hours and Whitney, we don't have in there, that's about $220 right there. So the 150 is definitely light, in my opinion. And so I think we should be higher than that. Is 250 the right number? I don't know. I had coming in here, I was thinking, I think 200 is the right number, but you could talk me into 225. 250 sounds like a lot to me. Again, we're not looking for a revenue stream. It didn't, I'm not saying.
no, and that's cool that you did that, man, cause I like, that has a real
It's a
found.
quantitative.
Yeah,
yeah,
and
I like
so if it's okay, I'd like to withdraw my motion and make a new one.
Well, I mean, when are we gonna revisit this? Cause I mean, if we go to 200, this looks like we're already short. Are we gonna revisit it next year?
Yeah, I think that's why you guys already talked me into 225. I came in at
That's-
200. No one knows really.
That,
25 sounds better.
that's what I was
Well,
gonna
it's only
introduce.
20% over that number.
Yeah.
If you want, if 225 helps you sleep at night.
Right.
Well, I think there's a sound,
I don't sleep at all.
yeah, I think there's sound rationale for that, because my guess is that if I did the same analysis in Lead, where they have a way bigger commercial development coming in for some, like, the time that would be dedicated to that might be more, and so bigger things are happening.
Interestingly, probably the opposite.
Really?
Yes, big things tend to have, professionals involved.
Yeah.
Their
that's right.
applications come in very well developed, et
They get
cetera.
they get the packet from Gallagher, Callahan and Gartrell, and you go.
Mom and pop applications tend to be less well thought out and developed and require more staff time to bring to the board.
Consult.
Thanks.
So
Let's hear from Celia and Tiffany on this topic, please.
I just wanna know what was the total.
So my total, if we made it 225 and you have 75 for the advertising and $8 for the mailing, because that's our actual cost, that brings a total to 308. So if you compare the 225 to all the other towns, the low town is like 100, the high town is like 300, so 225 puts you
And
down.
Grafton doesn't have any.
I want to withdraw my prior motion.
Yeah.
And if you give me leave, I'll introduce a new one.
Please.
So I would like to make a motion that we raise the application fee to $225.
I would second that.
Okay, before we vote on it, any comments from the public here on Teams? Mr. Griffin, any comments? Hearing no comments, we'll move on to a vote. The motion on the table is to go from 150 to 225 for the fee, and then the advertising and mailing remain as they are. All in favor, say aye. Aye. Motion passes 5-0.
Yeah.
Good work. Good. All right, ZBA start time, let's do an easy one. So right now it's 7 o'clock. I just want to throw it out there. Would it be easier for us? Would it be easier for members of the public, coming in, with an application to start at 6 or 6:30? Before we get there, if it's a non-starter for people, we need to know about that. So, what do people think? If I remember right, last week you were like, no way, last month you were like, no way.
Yeah, I like having dinner with my family.
Because the meetings are long and it gives us chance to get a leisurely supper. If there are kids to take care of, I have to take care of my dog. But if we started at 7, I'm better prepared.
Okay,
It really doesn't faze me either way, but I think that I like what you're saying. The only other point I have is like sometimes, and Bill can probably appreciate that with like sports season, right? Like coordinating, getting
Yeah.
kids to there, and this parent then comes.
Yeah.
It would be tight for 6 o'clock sometimes.
okay.
Either's fine with me.
Fine. Steely?
I'm fine,
You're fine.
whatever they.
Yeah, so I would prefer 6, to be quite honest, because I go to the select board meetings sometimes and they're at 6 and I find that good, you're out. It's nice, you're still full time. However, I'm not married to that. 6:30 would work for me. But by the same token, if it's gonna cause issues and you guys would both prefer 7, I'm fine leaving it at 7.
Yeah, the only thing I would like to put out there to everybody is that if we had something that we knew, like, let's say we had a case that got appealed, the lawyer got involved and we needed to talk. And in one instance, or there's a case that's gonna be huge, because we've had some where this room is standing room only. And when that happens, you know you're gonna be in for a long night. So it's like, maybe we should start earlier so we don't go home at 11. I did like what the lawyer said today, though.
Yeah.
You could put in there a stop time, because I will tell you, I've been here past 10 o'clock
Yeah.
before in this room, and I'm not a fan of that.
Yeah.
I think I think what Tim says, that if we have something that we know is gonna take 49 hours, that we start earlier.
Well, it's just that we keep that in the back of our mind. I don't think we need to have it as a rule necessarily, but there have been, I think it was like the solar array thing, that just, you never know. It's gonna be some weird issue that just lights people up and you're like, oh.
Yeah. So I think what I'm hearing, if I could summarize, actually, before I summarize, public, any comments?
I just agree. I agree with what you guys just said. It start at 7, you're letting everybody get here, and then the cutoff time, and just keep it well organized. And then if you have to have a follow on, do a follow on.
Thank you. And for the record, what's your name, please?
Jason Carter.
Got it. Any comments from teams? Thank you, Jason. No comments from teams. If
Do we want to talk about a cutoff time?
I think, I agree. I mean, I think 10 o'clock, we're a ridiculous stage.
I could get behind 10 o'clock, yeah.
Yeah, I mean, it rarely ever happens, but 10 o'clock
What
is
is it
like,
going to be like? Our rules state that we must stop at 10.
Well, I also think if you get somebody that's waffling and it's 9:40, you have the option to remind them.
We'll have to meet on this issue again unless you decide now.
And you can
You
continue.
would have said 9:30.
Yeah, I mean, again, I think if you make it 10 o'clock, anytime we're still sitting here in the thick of a hearing at 9 o'clock, it gives you the option to say, I want to be cognizant of
Yep.
because 10, I've been here at 10 and I can tell you that felt ridiculous.
So,
Yeah.
good, we'll move this to a motion and a vote, but just one more thing I want to say, if people can please take personal responsibility for being concise with your points, and sticking to topic, that'll help us move along much more efficiently. So if somebody wants to make a motion, I'm hearing 7 and 10, that's probably a good spot to start.
Move that our meeting occur from 7 to 10.
Second.
All in favor, say aye.
Aye. Rob, is there a way that they get that on the website? I don't know. I'm always a fan
Oh, that's
of,
a good
we told you.
Yeah, we could put it up on the web.
Yeah.
Okay. Preliminary discussion of ZBA rules and procedures. So these are the very front of your book. And you can see the lower right-hand corner, it says the last updated in October of 2021. It's a 5-page document, very front of your book, the first 5 pages.
Pass the table.
There's not a tab,
This
and maybe everybody doesn't have it.
Mine's a
is
little
a
bit.
lovely
Oh.
book.
Tiffany's is under a tab right before the handbook.
The rules and procedure.
There should be a tab that says rules of procedure
Yeah,
in your book.
there's a tab. In mine, it's at the last section
There you go.
there, it says rules and procedure. And,
So when we did Dan's book, we decided it was gonna be in the front, but now you got a new book.
and I would say, the only thing I would say is this says December 2021.
I have October 2021 on mine.
Yeah, well, that's
I know.
what the printer
Right.
says.
Oh.
What I can tell you is
You
the
update
process to change these started in 2019.
I remember. Yeah.
You remember, and so it's kind of a pain in the butt, so
Okay.
I would think it out before because there's this, you gotta do it, what, 3 times? Don't you have to do it 3 times?
We have to have a public hearing on it.
Yeah.
Yep.
Yeah.
Yep.
So here's what I'd like to talk about tonight. The first question I have is, are we in agreement where these are 4 years old or nearly 4 years old?
Oh,
To
yeah.
take a fresh look at these. Does anybody disagree with that?
Well, what do you feel has changed in 4 years about the process or about?
Could I suggest that this be an assignment for the next meeting, because it's nearly 9 o'clock now, and if we need to go over it, a sentence at a time, we'll be here.
No, so here's what we're not gonna do tonight. We're not gonna go over it a sentence at a time. We're just gonna decide, do we want to take a look at these? And if we do, what's the process to take a look at them? We are not, as I said in my email that went out to everybody, we are not going through these line by line and trying to alter them tonight.
No.
Well, could we decide to look at them before the next meeting?
No, we don't even have to look at them.
We don't even have
Don't
to.
even have to look at them, Susan.
My thought on why to look at these too is it kind of goes to what the attorney was saying tonight. There's potentially some hand grenades gonna get thrown at us by the state legislature. And I just, there might be something that we need to address in here once that happens.
Yeah.
And we should know some of that pretty soon. But I think the other part is, the issue of, the officers and things like that. I just don't, it's worth looking at them eventually, but if we think that everything's fine and dandy, then no, we don't need to. I'm just concerned that, it would, I don't think it'd be a bad exercise to look at it. Some people might be seeing this for the first time, by the way. 'Cause
Susan, your name is on the back. You signed
Did I sign that? I don't remember it.
Okay.
Well, I'll
um,
read it again,
shall
so
I-
I know what we're talking about.
So one of the things I'd like to point out is oftentimes what I'm finding is somebody will ask a question on this board. And then the next person that starts talking doesn't even pay attention, they just go their own way. Bill asked a question. And Bill hasn't gotten a response yet. So Bill, what was your question? Maybe we could respond to that.
Oh, I was wondering, what was leading to you to question whether or not we need to revisit these? Was it something that you feel like has changed, about the ZBA, that it needs another look? 4 years sounds like a long time, but
Yeah.
really for, like parliamentary procedure, it doesn't seem like.
So,
Seems like a.
I'll be honest, to me, it's 4 years felt like a long time, number one. And then as I started looking through them, there were some things that I didn't see in here.
Okay.
Such as the times, such as how are vacancies filled? You should go look at your rules or procedures to see how vacancies are filled, in my opinion. So I think there are some,
Isn't that perhaps covered by something that's not in our rules of procedure?
Well, for example, tonight, we just voted to make it 7 to 10.
Yeah.
And if you look at the section on meetings, the backside of the first page.
Yeah.
Regular meeting, blah, 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 at 7 PM.
There you go.
So we should amend this to read between 7 and 10 PM, because we can adopt a policy ad hoc. But once this is behind you and you say, this is why we did it this way, because you kind of squared up,
and
right?
I'm also not looking at work just for the sake of work. I'm
No.
busy enough. And maybe while we're reviewing these, we find, you know what, this is pretty damn good. We don't need to change it, or we only need to make some minor changes, and that's fine too.
There was a fair amount of effort that went into it, right, Rob?
So
What-
perhaps you just
the la-
calling attention to it. You're like, these are the rules, make sure you know them.
I'm sure.
Fellow
it
members
is,
of the
but I saw it, but I don't remember.
Yeah.
It was, what I can tell you is, I think the time they have been done, we went to these because I want to say it was Ed McLaughlin made a point of it, because they hadn't been touched since your brother was you know, so that was like,
Long time.
it's in my head, I'm going, well, that was 10 years ago at least.
Well, it's 2025. It would seem to me that it would be good to say, go home and read them before the next meeting, and then we'll bring it up.
So I'd like to do this. Tell me what you guys think. I would like to do two things. One, that's fine, Susan, we can ask everybody to read them, since it doesn't appear that people have read them in a very long time. And number two, I would like to ask that Tiffany go back and put together a skeleton of a process she would go through in order to review these. What would that look like? What would you, what documents do you have to find out to see how do we do this? What exists now? What's the timeline look like? What would the roles and responsibilities be? And then at our next meeting, I'd like you to come in and I'd like you to say just that. And then I'd like other people, if they have reviewed it, to come in and say, you know what? Yeah, I reviewed it and we really do need to look at these. I saw some things that, and we don't need to talk next week about what they are. But I just want to give people a sense of, should these be reviewed or not? And if we all come back next week and say, next month and say, no, we don't need to review these.
I would like Susan to look for any grammatical errors in them. I'm being serious, like, she'll find it.
That's fine.
But seriously, like,
That's fine.
those should, if they're codified, they should be correct.
Are people okay with those two objectives?
I like that.
Next week?
I'm assuming Lebanon has
Yes, it's.
rules of procedure.
Okay.
Do you send those to me? I'd like to take a look at those and see.
So the two things, I don't think we need a motion or a vote on this, but the two things we're gonna agree to, we can put it in the notes, is we will all look at the rules and procedures and give a 30,000 foot reaction to them. We don't need the infinite detail on every point. We just need to say, yeah, these are really good, or yeah, this is a worthwhile process, or we need to blow these up and start over again.
Yeah.
So I want to get people's knee-jerk reaction. Tiffany is charged before the next meeting with
putting together, doing research and then putting together the process by which we would go through if we are going to review them.
I like it.
Can I open it up to the public? Any comments? Anybody on Teams have any comments?
Are we
Hearing
going
none,
to do the alternate members discussion tonight?
we are, that's coming up. All right, everybody good with that topic?
Like, it.
Yeah, that's
Right.
fine.
I'm sure Tiffany didn't plan on homework, but
Uh,
welcome to the jungle.
All right.
Guy homework.
Next topic is a preliminary discussion of communication with the planning board and the select board. A couple of things I'd like to say first to kick it off is we are not under the jurisdiction of the select board nor the planning board. Having said that, I have a great deal of respect, we all do, for both of those boards. The fact that we're not under their jurisdiction was a conscious decision of the state that we remain separate. We are instead a quasi judicial board with a responsibility that should not be influenced by outside forces. Having said that, I believe that open and transparent communication is in everyone's best interest. So let me pause here. Does anyone have any comments on that thinking?
Not so much about the select board, but I think that Rob is our person to communicate with the planning board because he's also their administrator. And, he does it anyway, I think. But it would seem to me that communicating via Rob is the way to do that. I don't know about select board, though.
They, I just want, they have access though to plan the minutes. I mean, they can have, if they wanna know what we're doing, because of our role here down, that they have access to the minutes of what we are doing. I think that would keep us safe. And if they need explaining,
Yeah.
they can go to him.
Okay.
Dan,
Yep.
be brief. One is, though, I can think of a time when I sat as chair and I came in and the planning board and the zoning board were like, I don't want to say they're half the Middleton toys, but there was never any talk or even necessarily alignment.
Yeah.
And we had overturned them a couple times. And so I asked Rob to extend an invitation to David Frack for like a either a joint meeting or invite him to come to ours. And I think that eventually happened like 2 years ago, but the process for that started like 4 years ago. And my thought here is that one of the things that I heard today that I'll admit I was ignorant of is the attorney says that we actually, meaning the zoning board, can present an ordinance or to this, we can legislate because what's always happened is the planning board sponsors such and such, and then you see on the ballot, planning board recommends this by a vote of 4-2 or whatever it is. And in the spirit of like, if something needed to happen in an ordinance, it has always kind of been a contention of mine that if the planning board is thinking about changing something in here, a discussion with us would not be a bad idea. And I think that waiting 4 years to have that happen is not, it's pointless, because by the time it happens,
Yeah.
things either passed or fail. But I also think because we are the ones seeing it reverse engineered, our input, and they are seeing it, from the front line, the combination of those two brain powers would probably lead to some better ordinance. So.
Yeah.
Question, do proposed ordinance changes wherever they originate, do they come before this board for
No.
review before they go public?
No, never. Yeah,
They should though.
I've always felt like ZBA should be, yes, if ultimately they're putting them on the warrant and their recommendation, I don't need us on the ballot saying the ZBA recommends this 5-0 or whatever. But I feel like if we're gonna change ordinances, and then we're gonna later be applying that. What, like, it ought to be a three-way discussion between Rob, I don't know, maybe the building inspector in some cases too, us and the planning board about how does this work? Almost like when that's what the legislature does, right? When they get these joint legislative committees to talk, senators and reps. And so I've just felt like if it were needed, I'd like you to be able to, as the chair, be able to say, hey, I'm gonna contact Frack, or who, is it Frack or is it's Frack again? I thought it was Dan.
Tomorrow night, they elect their new.
Okay, so at any rate, like, so that you know, whatever, I'm not saying any, maybe the email includes Rob, and say, look, we know that you guys are, do you have plans for pending legislation at the next town warrant? And if they do, especially because, by the way, things get a little slim in November, December around here for hearings. It wouldn't be crazy to have a joint session to talk about what are we gonna put? Because every year there's 3 or 4 things, and then we go through this exercise of somebody telling us what those 3 or 4 things are.
It was done at one time, I'm sorry.
It was,
Yeah.
How many years ago?
One time we did that. a long
like
time.
Paul Mirsky years, like then,
Yeah,
Okay.
so.
100.
that was part of the whole, every time the plan, any zoning amendment, anything would go to the ZBA. And they would confer back and forth because, as you say.
Yeah, I started in
we see
03.
What's
Yeah.
going on.
Okay, Tiffany?
I can confirm other places that is the first process and procedure that zoning amendments do before they, go to public for vote, or whether they need vote or not, they are reviewed and discussed by the zoning board.
Interesting. So I'm not sure if I agree with doing that yet or not. I need to look into it a lot more and think about it a lot more. But to me, it appears that, I know Rob does a phenomenal job, right? He's locked and loaded with the planning board. If there's something that the select board needed to hear, it would
It's
get.
got more hair than his brother.
Yeah, what I don't know, it's just in life, I think communication is so important, whether it be in marriage or with a boss or anywhere, right? Communication. So the idea was to go maybe once a year and maybe PRN as needed after that. To sit down with them and just say, hey, want to give you an update as to what's
Yeah.
happening on the zoning board. We talked about rates, here's what we did, here's what we decided, we talked about blah, 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 we're talking blah, blah, blah. Nothing more. I'm not looking for their approval. I'm just trying to start a dialogue with the zoning and with the planning. It would be the type of thing, it would be in this room. I'd come up, I'd sit at the table. All of you guys would be welcome to join in the audience and what's the downside? I guess is what I'm thinking.
I think it makes sense.
Open a line of communication,
Yeah.
bi-directional.
Yeah, I don't think.
This planning
But
board
it
have a
ought to
monthly,
be done when we don't have any hearings.
maybe just one time a month or two.
It's twice and planning's twice as well.
Perhaps we could once a year join them for their second meeting of the month for their meeting.
To get thin for them
Items at the
in
same-
November too. I mean, I know we get Thanksgiving that month. It's usually November, December, things are just pretty thin, and that's.
Comments from the public, comments from teams. So. Here's what I was thinking, if you guys adamantly, in adamant disagreement, let me know, please. Sitting down and asking if I can get on the select board agenda for May 19th and the planning board agenda for May 28th. It would be,
I can't do it.
No, Dan,
you don't have to, you'd be, optional, I'd love to have you if you can make it, if you can't, that's all right. Would you be opposed to my doing this?
I think it's great.
And is there any
Fine.
pitfalls?
What would you talk about? I mean, that close a date, I would imagine you have an agenda.
It's basically what was on here, and just to say, hey, we've got a new board, and here are some of the things that, we've been talking about. Yeah, I think those are important things.
We do have comment from the teams.
William,
You're muted. There you go.
There you
Yes,
go.
I think that would be a great
you know, avenue of communication opened between the boards. I think that would benefit everybody.
Okay, thank you. All right, hearing no adamant disagreement, I will send out an email and let you know when the dates have been confirmed. And what the topic items will be. Good, good. Discussion on new alternate ZBA member. Bob Cusick has resigned as an alternate. And we are looking for one replacement. Our rules of procedure say that we can have up to 5 alternate members. I don't like that idea for the following reason. I want our alternates to sit at the table and I want them here to participate. If we have 5 alternates at the table and they're all participating, it's chaos.
Yes,
We don't need that.
I think the most we've ever had was 2 here.
And 2, I think is
I
perfect.
started out as an alternate, so I could learn what was going on. But I was wondering, I was looking, there was Sharon Buffet coming to our meeting. She might make, and she has lots of opinions. Lots of opinions, but she might make a good alternate. I spoke to Mike, cause I think he really knows the law down to the bottom of his toes. That he said he might be willing to be an alternate. And one of the things that I don't know well enough is the law. I'm learning and learning and learning. And for the zoning board, that's really critical.
I think that's great. I think the grapevine is a nice way to find people. But I think we need an official process. I have seen with a couple other boards, they've had some missteps lately, nobody's fault, just, but I think we need an official announcement that we have an opening and we're looking for an alternate. We need very broad communications regarding that. We need to have a formal application with a 30-day application period. We need to review the applicants by the entire board. And then we need a vote by the entire board as far as who we're going to bring on. We don't want to do this just one-offs. That's not what we're looking for.
Oh, I got voted in. I
Okay.
can apply and get voted in.
Yeah, I mean, it's tough to get people a lot of the
I
time.
know.
But I was.
So which has to be to post it.
before I ran.
Post it.
So, yeah, Rob, please, if you could post it in a town, well, let me hear, any other before Rob does that. Are people comfortable having a formal process?
I concur. If we cast a wide net, we'll get a lot of information.
Yeah, and I think what your idea about the application is good.
Yeah, okay,
Because you really want to know about the person you're gonna.
okay.
Yeah, I like it. I think it's orderly. That's the word I was looking for. I can say there's a basis for doing it this way. We picked this person because of this.
Okay.
I wrote, did I write a letter or did I have?
I don't know what you did, Susan.
You wrote a letter.
Comments from the public. Comments from teams.
Want to be an alternate?
Okay, so Rob, yeah, if you could put together a townwide email that would go out, I will look to follow that up with a listserv post. And then we'll look to get it in the town newsletter in June. And if we think of any other ways to get it out there. So if Rob is to send an email out by, say, May 15th, today being the 13th, that would make the deadline to apply June 15th. And that would give us the opportunity to review all applicants and applications at our meeting on July 8th.
That's fine.
Okay? Yeah, good.
Be sure
All right.
you include Mike, cause I already asked him.
Well, he's gonna see the post, you know.
Yeah, okay.
All right, the last thing I want to mention is, what I wrote on the board here. If you want to take a picture of it, great. But what I'm trying to illustrate is that we have some resources available to us at New Hampshire Municipal Association Legal Services. That's their email address, their web address. And then Steve Buckley is the best person there for us to speak to. He's the one that knows land use law. Jonathan is an outstanding attorney, I'm sure. But it seems like Steve is the best go-to for us. I talked to him today. He was very good, very serious, which is what you want in a lawyer, right? From a training perspective, the New Hampshire Office of Planning and Development, the OPD, their website is listed there as well.
They have a couple of training opportunities going on. The first is these, what I call lunch and learns, they call planning, what's that middle, second word, Rob?
Lunch and learn?
Lunch at noon, planning lunches at noon, plan. Their monthly service, April 17th happened, and now they posted online. If anybody didn't make the April 17th and you want to see it, it's now online. There will be no session in May. I'll explain that in a second. And then June is June 12th. It's a brand new session that'll happen at noon. If you get the opportunity to do it there, great. If not, you can do it online. The reason they're not having a May session is this past Saturday, May 10th, they had the Spring 25 Planning and Zoning Conference, which went from 8:45 to 3:30. I did not go. There was a specific ZBA track. And it is now available on the YouTube channel. If you go to the OPD YouTube channel, it's available there. And they will soon have it posted on the OPD website. My goal is to get on that zoning track, and I'm not gonna do it all at once, I'll tell you, but I'm gonna try to do a couple hours, and I'm trying to get through the whole thing. I think training will be one of the keys to our success. So that was that. Questions on that? Any other topics from it?
Yeah, Dan, real quick.
Yeah.
I asked Rob to print, there's a bill headed, House Bill 631, it's
Okay.
headed to the governor's desk. And the reason I bring it up is this, basically the analysis of this is what it does is it requires municipalities to permit multifamily residential developments on commercially zoned land. So this is, this whole issue of allowing formerly commercial places to now be used as residents. I think we could see stuff like we saw last time will be directed to that those, you cannot require a variance in that. Those are approved. You can take your commercial space and make it residential and we don't get to say boo about it. And it passed both the House and Senate, so
So it's on the governor's desk?
yeah. And I would suspect that there's huge bipartisan support on this. There's most everything that's happened in Concord has been right down party lines, but not on this issue. I don't think they had Enfield in mind, but I think it's pretty clear that.
And the two bills already reconciled and everything, and she's got one sitting on her desk? Really? Okay.
And I could see it. I mean, I don't want to see JCPenney's turn into apartments, but it very well could.
Steeplegate Mall in Concord is being turned into apartments.
It is.
What is, Rob?
Steeplegate
Steeplegate
Mall.
Mall?
Well, it was squatters were living in it for a while at one point, so
Well,
figured we might as well charge rent. But that said, I've been listening to a lot of stuff and this came up. I'm like, I gotta look at that. And I'm like, what?
Has the planning board talked about this?
Yeah, we've had several conversations. There's a few others that are even
Oh,
more scary.
yeah, no, they're scared. This one just literally.
There's one
I
that
came
creates
from-
2 acre zoning pretty much anywhere. I mean, it's like,
Yep.
zoning be damned kind of thing. So we're all kind of scared to death as to what it's
Yeah,
gonna
they're
be.
not looking at any of the towns.
Yep. And it's interesting how New Hampshire's like, oh, we're not, let that local have control, but then it's like, no.
Yeah. I mean, that, the cry that you hear is housing.
Yeah.
So
Yeah.
that's where it's coming from.
Yeah, housing, and the world population is going down and people are having fewer babies. It doesn't make a lot of sense.
You want a motion to?
Were there books? You said something about there being.
Move to adjourn?
So Rob had these books. Do you have any more? Are you
I
out?
don't, I'm totally.
Can you
How
order
much
some?
are they? You know? I know, $200 or
That's-
something, right?
They're probably online.
Yeah, so
Oh, yeah, no, it's
as
all.
long as, I will make an effort to make sure there's always one of those books in this room when we're talking.
Yeah.
For sure, that, you guys,
But they
there's
don't-
several of them. I know you got one. What's that?
They used to give them. I have one that was given to me.
Oh, absolutely. So what happened was, we did not get noticed that they were coming for the order. So we didn't get the order in time to order unlimited, and plus, we've reduced our budget on the books, yeah, to $100 or something, so. We
Hence why
don't
we
really
raised the
wanna buy a
fees
lot of
to-
books for people, but then
Well-
everybody wants a copy of the book, so we were able to put it in an order, and I got about 10 of them. And we've been passing them out. You guys got one, I think you got one. So, we'll have to kind of share them, and next year I'll make an effort to make sure we boost the budget back up.
Maybe our.
Everybody seems to like
legislator
books.
could get us some.
No.
It's LexisNexis, and so if you,
Yeah,
if you're paying full freight, they're like $120 a piece.
I make
which
a
is-
motion
Which is insane.
to adjourn.
Second that.
All in favor, say aye.
Aye.
By the way, it just occurred to me that the last time we raised the filing fee, we raised it from 75 to 150, and we just raised it from 150 to 225.
Another 75.
Which is
Consistent.
so, I didn't think of that until just now, and I went, well, we raised it